Thank you very much, Ayelet, for a thoughtful, thought-provoking lecture. And I now call upon Avishalom Westreich from the College of Law and Business, an expert in Jewish law, family law, and jurisprudence. Actually, a natural commentator to a paper immersed in family and statutes. Please.
Thank you very much. Good morning, everyone. Thank you, Ayelet, for the fascinating paper. A paper which views legal culture as plural and dynamic, but not only that, a paper that gives us an enlightening view on the interaction between law, literature, and culture. And in this interaction, literature really participates in legal culture. So basically, I accept the structure of the paper and would like to contribute by making three observations. First, proposing more far-reaching understanding of the presumption of legitimacy concept, which is a deconstruction rather than pluralistic, rather than legal plurality that you have proposed. Second, quick remarks on parallelism in Israeli law and Jewish law to the presumption of legitimacy. And third, back to literature, a little bit discussion on the presumption of legitimacy in modern Israeli literature. So let me start from the first point. As the Ayelet argues, and I quote, you said it a few minutes ago, the presumption of legitimacy is not an abstract or universal form or rule, but its epistemology is in itself conventionally and historically determined, and in dialogue with other Victorian conventions of knowing an ever-shifting world. So my proposal would be to use most suitable, to my opinion, analysis, which is post-structural literary analysis of the text, and mainly deconstruction. The argument, the concept, the presumption of legitimacy has no constant meaning, but it is changing all the time. It is ambiguous, sometimes even manipulated, and above all, it is unclear. What it means that is that the concept does not really refer to any reality, even not to the legal reality. I would like to explain this point a little bit further. We can analyze the concept of the presumption of legitimacy in three ways. First, the structural reading, which see the legitimacy, both two concepts, legitimacy and illegitimacy, as central legal concepts, even if distinguished from reality. Constant, but may be distinguished from the real reality. Another option is a moderated post-structural understanding, which I think this is your view, Ayelet's view, a pluralistic reading of the concept of the presumption of legitimacy and illegitimacy. But the next step will be to point on the vague meaning of the concept of the presumption, to see its dynamic, to see the change in time and place, even to add some political aspects, which you mentioned in the paper itself. For example, the fact that it depends on the place, on the authority of the king, and other aspects which may be political. More than that, the presumption of legitimacy becomes meaningless throughout the plot, or I may define it as deconstructed throughout the text. We start with, and I quote Ayelet, a strong bias in favor of this presumption, in favor of the presumption of legitimacy. Then we move to a presumption that has a potential of being rejected, unless, and here I quote the plot itself, unless the marriage should be disproved. And finally, and I quote Ayelet, legitimacy needs to be proclaimed rather than presumed. So, in this, we can conclude from that what was clear at the beginning of the text, at the beginning of the story, becomes unclear at the end. Not only plural, but unclear. Now, to my opinion, the constructing process is emphasized at the end of the plot. The novel ends with a slightly surprising way when both the Marquis and his son die. But why? Why did the author choose to end this story in this way? On the one hand, it solves the practical problem, who will be the next marquise. But on the other hand, it doesn't solve any of the inherent questions, any of the problems of legitimacy and illegitimacy, any of the inherent conflict. Ayelet responds that, and I quote, "The separation of infidelity and illegitimacy in this novel challenges our ability to know what is true and what is real. And this can be taken a step further. By the end without an end of the illegitimacy conflict, the author claims that the discussion was completely meaningless. That is, there is no real importance to the question of legitimacy or illegitimacy, not in reality, not in the legal context. So finally, we end the story with indeterminacy of the presumption of legitimacy, or a deconstructed concept, rather than plurality." My second point will be the illegitimacy in Israeli law and in Jewish law, and I'll do it very short. The paper refers to some modern views on the presumption of legitimacy in notes 6 and 7, so it gives me the legitimacy to discuss also our current view on the issues. Now, Israeli law takes into account the view of religious law, and this is due to the spatial character of family law, which govern in many aspects, many of its main aspects, by the religious law. Now, in Jewish law, similarly to your discussion, legitimacy and illegitimacy are dynamic legal concepts, and many times are not at all realistic. According to Jewish law, illegitimacy, which is defined as bastardy or mamzerut in Hebrew, is a case when a child is born as a result of forbidden relationships between a married woman and a man, which is not harassment, but it requires that there will be a declaration of bastardy. It's not only the reality. So here as well, Jewish law uses the presumption of parenthood, and in many cases it ignores reality for legal reasons. For example, if we take DNA tests are used for several reasons, for several purposes, but they will not be used, or even will be ignored, when a case of bastardy is in question. In this respect, Israeli law follows, we may even say, fears of the Jewish law, and adopted this very view in the genetic information law of the year 2000, which demands that there will be a limited permission for genetic tests in cases that bastardy is possible, and the law also demands that a consultation with the president of the High Rabbinical Court should be made in order to prevent the illegitimacy of the child. So we can see that in Jewish law and in Israeli law, and it was very, very short, the concept of legitimacy and illegitimacy is dynamic, is not realistic at all, and it depends on the interest of the law. Now, my final point will be by turning back to literature, but not to the 19th century Victorian literature, but rather to modern Israeli literature. Shai Agnon was awarded the Nobel Prize in 1966, discusses in one of his famous novellas, amongst other things, the question of legitimacy and illegitimacy. In Ve'haya Yaakov Lemishor, the crooked shall be made straight, the hero, Menashe Chaim, comes back to his town after considered dead. His wife, meanwhile, had married another man and had had a child, which, if everyone knows that Menashe Chaim, the hero, is alive, will be declared as a bastard, a mamzer. Menashe Chaim decided to continue his life in the cemetery without anyone knowing about the fact that he is alive, rather than going out and making the child an illegitimate child. Now here, legitimacy depends on Menashe Chaim, who is presumed to be dead, but in reality is alive, of course. Some of the people around do suspect the fact that he is alive. The cemetery keeper even knows that he is alive, but the child is still considered as a legitimate child because no one tells the real truth. Now, in this case, the real crooked the effect that the child was born to a married woman still stays crooked in reality. But we can learn from the story something that very important about presumptions. Based on a false presumption, the presumption of death, in the legal, fictional realm, the child remains legitimate. So according to this realm, the crooked is indeed made straight. Thank you.